Hey everyone, welcome to Tathastu. My name is Amit and I hope you all are doing good. Well, today we are going to talk about sources of Indian Constitution. We are continuing our series of Indian polity. Yesterday we talked about salient features of Indian Constitution. Today we will talk about the sources of Indian Constitution. Indian Constitution, a beautiful document which has been crafted by Constituent Assembly, and it took them almost 3 years, and to be precise 2 years, 11 months, 18 days. And what took them so long? The idea of making this document, the idea of making Indian Constitution a balanced one, by taking examples from the other constitution, by observing and analyzing other countries, their cultures and their constitutions, and then making a document which suits the needs of Indian society, India's socio-economic conditions. Okay, so we'll see the different sources, the different countries from where we derived our constitution. But before that, here's a quick information for you. 4 beautiful courses, as I always say, 4 beautiful courses, because they are 4 beautiful courses have been designed by Tathastu team. Number 1 is MSLV, Main Success Launch Vehicle. Another one is PSLV, that is Prelim Success Launch Vehicle. This is coming soon. The third one is NCRT module, and the registrations are open here, so you can get yourself registered. The fourth one is philosophy optional. New batches will start from tomorrow onwards, 15th of September, and Tanu ma'am will be taking the class, so you must be very excited, as we all were, as when we were preparing for UPSC. So this is the contact number and the address. You can directly come and contact the team. Now let us start with the sources, with this topic, the sources of Indian Constitution, the different sources of Indian Constitution. So the Indian Constitution is a remarkable document created by Constituent Assembly, and it took them nearly 3 years, as I said, to be precise, 2 years, 11 months, 18 days, to put it together. While some ideas in the Constitution came from other countries, but it would not be fair to call it a copycat thing, or it's a bag mixed with different ideas and it has been copy pasted. There are few critics who call it with this name, the copycat constitution, but it has been made, that is why it took so much time, that is why it took so long to analyze the constitution, different constitutions, to observe the constitution and the socio-economic condition of those countries, and then matching it with the socio-economic condition of India's, the contemporary India's socio-economic condition, and then evaluating that would it be viable to implement this particular feature, this particular minute feature from whole of the constitution, be it from United States of America, United Kingdom, or any other, Canada, Ireland, or other constitutions. Okay. So these borrowed ideas were important for any government and its people, and they were adapted to fit India's politics and India's governance. So it's a unique and valuable document that suits India's needs. Now we'll see what are the different countries and what are the different features which have been borrowed from these different countries. Okay. So from United States, broadly, our constitution, as yesterday also we talked, that our constitution is heavily reliant on 2 things. One is Government of India Act 1935, and another is the different constitutions of different countries. Okay, so we'll talk about everything, the Government of India Act 1935 and these 10 constitutions. We'll divide this video into 2 parts so that it don't take so long a video. We don't want to make a video of 2-3 hours. Okay, so we'll try to compress it, and we'll try to make a short, crisp video, and we'll try to divide it into different parts. Now in first part we'll cover half of the countries and their borrowed features. So number 1 is United States of America. From here we took these features and then we incorporated into our constitution, our Indian Constitution. Number 1 is fundamental rights. Number 2, judicial review, the power of Supreme Court or the High Court to review that whether this constitution which has been made is does this stand the test of law, or does this stand the test of constitutional viability. Third one is independence of judiciary. Our judicial system is integrated, where there is Supreme Court, then High Court, then lower courts, and then on the other hand it is also independent in nature. The post of Vice President, Some people criticize it, some people say that it is important, but this particular post has been borrowed from United States of America. So these are the things which have been borrowed, and these are the countries from where these have been borrowed. Okay, so the impeachment of the president. So these are the things. There are many things, but broadly these are the things. Second one is United Kingdom. From here we borrowed parliamentary government, single citizenship, cabinet system, prerogative writs, and bicameralism and legislative procedure. So these are the things. On these two countries we are heavily reliant. These are the two countries where it is said that one of the most vibrant democracies, if it is somewhere, then it is in United Kingdom and United States of America. And as we wanted to be a vibrant democracy, so when we were borrowing, we borrowed so many features from these two countries. Okay. From Canada, there is vesting of residual powers in center, federation with a strong center. Now, yesterday when we were talking about the salient features of Indian Constitution, and we were saying that we have a unique ability, that we have a federal structure, but this federal structure has a unique ability. It can turn itself into a unitary one in a night's time, in a day's time, and that too without an amendment. Okay, so that particular feature has been taken from Canada, the federation with a strong center, and that the power has been given strong center by putting emergencies, although the power of emergency has not been taken from Canada. Appointment of state government by centers and advisory jurisdictions of the Supreme Court. From Ireland we have taken directive principles of state policy, methods of elections of the president, nominations of members of Rajya Sabha. So the nominated members, the 12 nominated members who are there in Rajya Sabha, they have been this idea has been taken from Ireland. And the complicated method of electing a president, we all know that there is a particular chart which is there in our Lakshmikant, and at the first glance it seems quite scary, and that quite scary thing has been taken from Ireland. Directive principles of state policy, fundamental right has been taken from, last slide हमने cover किया अभी, it has been taken from United States of America. DPSP has been taken from Ireland. Okay. The fifth one is Australia, freedom of trade, commerce and intercourse. Now this is one of the things which has been taken into fundamental rights, and it has been taken from Australia. Concurrent list, the idea of concurrent list, where a central list, state list, and then there is a list where both center and state can make their laws, and that is concurrent list. Joint sitting of two houses of the parliament, ये कि अगर दोनों houses कुछ फैसला न कर पाए तो बीच का रास्ता निकालने के लिए the idea of joint sitting has been taken from Australia. Soviet Union, from Soviet Union, obviously the fundamental duties. Yesterday there's a video which has been uploaded yesterday on YouTube, and that was about the Cold War. And while covering about the Cold War, and while analyzing and studying the difference between communism and capitalism, and the ideological fight between USA and USSR, we have been talking about this thing, that how Soviet Union had this communist idea. The Soviet Union and the government in Soviet Union had this communist idea, and from that idea this fundamental duty as a principle has been initiated. Then the ideals of justice, social, economic, political in the preamble. So we have this thing, na, we the people of India having solemnly resolved. So उसके बाद नीचे justice, liberty, equality, fraternity, and the justice of about everything, society, social, economic, political. Okay. From Germany, which was the erst Weimar, from Germany we have taken the suspension of fundamental rights during the emergency. So the idea of fundamental right has been taken from United States of America, and how to suspend that fundamental right during the time of emergency has been taken from Germany. Okay. France is the mother of revolution. The French Revolution is the mother of all revolutions, and it laid the foundation of modern socio-political setup in whole of the world. So from France we took the idea of republic. The idea of republic is when the head of the state is an elected one. Okay, it has not been nominated. There is an election, be it direct election or indirect election, but in this thing there is a head of the state in France. Then the ideals of liberty, equality, fraternity in the preamble, we all know that it is there, and it has been taken from France. And the French Revolution, the whole of the revolution was all about gaining these ideals, and that particular massacre or the bloody revolution which had so much blood, and it saw the sacrifice of so many peoples. So with those sacrifices, with those lives which have been lost, we got the ideals of liberty, equality and fraternity. From South Africa, we gained the procedure of amendment in the Indian Constitution. Okay. I'm sorry. So the procedure of amendment has been taken from the Indian Constitution, and then the election of the members of the Rajya Sabha. So how will we elect the members of the Rajya Sabha? This whole idea has been taken from South Africa, these two things. And then the procedure established by law. Yesterday we thoroughly talked about this thing, that there are two types of laws. There is a due process of law which has been followed in United States of America, and then there is a procedure established by law which is being followed in India. The idea here is quite limited, the scope of jurisdiction in procedure established by law, because there is already a law which has been established and you have to follow what has been written. In due process of law, there is a scope of analyzing, there is a scope of inventing, reinventing. Okay, so this procedure established by law has been taken from Japan. Okay. So these are the major things. There are so many things कि अभी हम यहाँ पे preamble को भी insert कर सकते थे, ठीक है? तो these are the things which we have talked about, but broadly अगर किसी चीज में divided है, if this thing has been divided into something, then these are the things in which these borrowed features can be divided, and then these are the countries from which these borrowed features have been taken. Okay, now let's move forward. The laws inspired by United States Constitution. Now we have, अभी तक ये trailer था, this was just the trailer. Now we are going to analyze everything quite comprehensively, but I promise you it would be crisp, it would be short, and I'll try to cover it as soon as possible. So the laws inspired by United States Constitution. Okay, so number one was separation of power. Now separation of power we know derived from US Constitution. If we see a historical development around it, so there are two important people who are associated with it. Number one is Aristotle and number two is Montesquieu. Okay, so the Aristotle proposed that the idea, due to excessive power vested in monarchs, this was the idea, the separation of power as an idea has been proposed by Aristotle, because that was the time, in that contemporary time, or the time in which he was living, there was a time when the king was all supreme, king had everything in hand, and it was upon him what to decide, what not to decide. Okay, so to make the society more balanced, to make the society more inclusive, this idea has been proposed by Aristotle, and the idea was of separation of power. And then it has been taken forward by Montesquieu, where he advocated dividing the state into three parts: legislative, executive, and then judicial branches. Okay, so as everything always evolves. Okay, there is कोई एकदम से क्रांति भी थोड़ा टाइम के बाद आती है. Okay, so there is a gradual procedure for everything, and this whole idea, the monopoly of king should be diluted, was proposed by him, and then it has been taken forward by Montesquieu. Okay, now the application in the USA is quite strict, and there is independent separation of power. It is so strict that the legislative procedure will not come into the path of judicial procedure. The judicial people will only give the judgments. There would be no say regarding, there is a clear distinction between all three powers. But in India, this concept is quite diluted. The application in India is more flexible, emphasizing the doctrine of separation of functions and checks and balances. And in India, you will see the judicial activism, where the judiciary would be guiding the parliament and the executive what to do. You will see the parliament asking people to come into the parliament and then plead and then talk about their guilty, and then the parliament will decide what's their guilty and everything. So we have seen some instances regarding that the few reporters, they have been called into the parliament. So the idea of separation of power in India is quite flexible. However, from where we have taken it from United States of America, this whole idea is very much rigid and it's firm, and you cannot surpass or you cannot enter into someone else's lane. Okay, second is federalism. Now this federalism, the idea of federalism has also been taken from United States of America, federalism, because the America was essentially a colony. People from Britain who we all, I hope you know this story of American Revolution, and I'm not going to go into that because it will take us too much time. We'll cover it in another video. But the people who migrated from Britain to this northern America, and then they situated there, and then this whole colonization of the whole of the America started. There were different colonies which eventually came together, and they made a united country that was called United States of America. Okay, so in USA there is true federalism with states forming a united nation, and then here in states they have liberty. In United States you will be having a citizenship of the country, and then the states are also powerful. The federal courts of these particular states, be it New York or be it Pennsylvania, these are also quite powerful. They can also give judgments, and there is no idea of integrated judiciary. The judiciary of United States of America, which is there at the center, and the judiciary at the state level, they are having more or less the similar power to decide on a matter. So the state government, there is dual citizenship. The state governments are also quite capable, and the judiciary is also powerful at the central level also. Okay, so the federalism which has been followed in United States of America is quite true, and it's quite close to the idea of federalism. However, in India, the critics say that India follows a quasi federal structure with a strong central government. Yesterday also we talked about this. In India, there is the idea that if the state governments doesn't follow the lead of the center, the lead of the nation, the government which is leading the nation, then eventually it would be called a constitutional emergency, and that the states are not actually binding with the center and with the idea of union, and maybe there could be a chance that presidential whole president power would be used, and the presidential emergency would be imposed here. Okay, that is why it has been called a quasi federal structure. Preamble literally copied from United States of United States of America. We emphasizing we the people as the source of the authority, and it says just like in United States of America, in India it has also been called that the starting three words are there it is we the people of United States of America, here is we the people of India, and both the preamble signifies that the citizens are the source of the power, and they give this constitution, and they give this whole nation state the resilience and the thing to stand on. Okay, so another one is fundamental right. Now the inspiration, many nations including India drew inspiration from USA for their fundamental rights provisions, like another nation. And fundamental right is one of the things which is fundamental, which is considered fundamental to your living, which is considered that for a holistic development of a person, there should be some rights which should never be touched, which should never be tampered with, and these are fundamental rights. In India, there are 6 fundamental rights. These are right to equality, and you will also read it here. These are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, and right to constitutional remedy. Now there is a quick question. B.R. Ambedkar said that out of these 6 fundamental rights, one fundamental right is the heart and soul of the constitution. Which one amongst them is that particular fundamental right? Please write it down in the comment section. We'll move forward. As I said that the borrowing from the American Constitution and the United Kingdom Constitution is, in numbers it is quite large, so we are taking a bit more time in these particular cases, in these particular countries. Another thing is impeachment of the president. Okay, so the formal process of presidential impeachment under Article 61 in the Indian Constitution was inspired by US Constitution. Okay, so this idea of impeaching the president has also been taken from United States of America, and in India it has been written into Article 61 of the Indian Constitution. The idea of judicial review has also been taken into consideration from the United States of America while discussing the 50 years of basic structure of the Indian Constitution, and when the country, and when we were discussing about the Keshwananda Bharti case and the 50 years of this whole doctrine, basic structure doctrine. So from there, this particular idea of judicial review. Now another question, is this judicial review mentioned, is this word is explicitly mentioned in the Indian Constitution? Yes or no? Okay, write it down in the comment section, yes or no. Okay, so the precedent, it has been taken from the United States of America, and there was an incident, actually there was a case, Marbury versus Madison in United States of America, which established the power of judicial review, allowing courts to declare government laws and policies as illegal. Okay, and it has been seen that whenever a judge gives a judgment in any part of the country, whenever there is a judgment in any part of the country, if there is a precedent, if there is a judgment in their own country, the judiciaries and the legal officers, the lawyers follow it, and if they don't have any thing regarding this, then they'll follow the lead, they'll follow the countries who have given recommendation, who have given judgments in some other countries. Okay, so be it Salomon versus Salomon case, or be it this Marbury versus Madison case. Okay, and this case gave the idea of judicial review, and then this judicial review has been followed in India, and then it has been further consolidated, and it further got consolidated by this basic structure doctrine. Okay, the post of vice president, now this has also been taken from the United States of America. There are similarities into the roles of vice presidents in both countries, but the idea of vice presidentship is similar in both the countries, but the vice president of United States of America is quite powerful. If there is unfortunate situation which arises in US and something happens to the US president, then there is a provision that the US vice president would take over as the president of United States of America. In India, there is no such provision. That is why it is said that the Indian counterpart, the Indian vice president, is not that much powerful. Okay, so we have completed this particular country and the United States of America, and the broad major provisions which have been borrowed from the United States of America into the Indian Constitution. Now we are going to talk about United Kingdom. Okay, so here, laws inspired by United Kingdom. So number one is parliamentary democracy. As I said, that the parliamentary democracy, India wanted to be a democracy, and fortunately we are a very vibrant democracy. If we just set aside some of the differences which are there in every country, then other than this, we are a very successful democracy. There's just a little spot of that emergency period. Other than that, we are a very successful, very vibrant democracy, and we try to follow the lead of vibrant democracies of that particular time, and two of them were US and UK, and then there were other European countries also. But from United Kingdom, we took this idea of parliamentary democracy. Okay, so there is one presidential in United States of America. The kind of democracy which has been followed is it revolves around the president. In India, which has been taken from United Kingdom, it is parliamentary democracy. Okay, so we wanted the group of people, we wanted our power to be decentralized, we wanted our power to be in the hands of different people, so there should not be a complete sway of a single person. That is why we chose the parliamentary democracy. So the parliamentary democracy, from here we took bicameralism. The parliament is divided into two houses, the upper house and the lower house. So Vidhan Sabha, Vidhan Parishad, the Rajya Sabha and the Lok Sabha. This idea, this is called bicameralism, and this has been taken from United Kingdom. The other one is cabinet system. The cabinet's existence and the election of the prime minister depend on the parliamentary confidence. Okay, that is why this particular no confidence motion, it gets tabled into the Lok Sabha time and again to check the confidence of this check the confidence of parliament into the existing cabinet, and if the cabinet lose that confidence, then obviously the government falls down. But this cabinet system has also been taken from there. Okay, although the cabinet the cabinet which is there is very much powerful, it is said that they are all powerful. In India there is a sort of check and balance. Then there is parliamentary privilege, the right and immunities provided under Article 105 for cabinet ministers and Article 194 for the state legislative assemblies, and these parliamentary privileges have also been taken from United Kingdom. Second one is rule of law, that the law is supreme. Okay, so the supremacy of law, and that has been taken from United Kingdom. The law is considered supreme. In India, the rule of law also applies, but any law violating fundamental right is void as per Article 13 of the Constitution. Okay, so there is an idea here, as I said, that we tried to make this document a living one. We tried to make this document as something which is quite balanced, which can walk the tightrope between two extremes. So yes, there is a guarantee of fundamental right, but there and the supremacy of law also, but the law should not, in normal circumstances, it should not curtail the fundamental rights. Although then there is also provision of national emergency, and then the situation gets dynamic, but we'll talk it somewhere around the corner. So then there is the idea of writs, and this idea of writs has also been taken from United Kingdom. So the fundamental right protection, citizens can seek redress against the violation of the fundamental and other rights through writs. Now this writ can be claimed under Article 32. Citizens can approach the Supreme Court under Article 32, and then under Article 226, Article 226, the High Courts have the power to issue the writs. Okay, and there are broadly 5 types of writs. Number 1 is habeas corpus, to have the body. Number 2 is largely about the command, mandamus, prohibition, certiorari, and quo warranto. We all know the quo warranto, to what authority. There is a stand-up comedy also, I think by Anubhav Singh Bassi, कि उनका जो UPSC जर्नी थी. So he asked him, oh no, I'm so sorry, this was a line which is being told by a student of Tathastu at Teachers Day. Okay, so he was walking somewhere, and the police officer asked him about the driving license and everything, and then he said quo warranto, by what authority. Although he got a tight slap, it was a joke, but it was a nice joke. Okay. Yeah, this particular joke was told by a student of Tathastu at Teachers Day. Well, let's move forward. The single citizenship, this idea of single citizenship has also been taken from United Kingdom. Every Indian citizen is recognized as solely Indian, promoting a sense of national unity. Okay, so there are countries where there is something called there are countries where there is a citizenship at the national level, then there is a citizenship at the state level. Okay, but in India there is only one citizenship, single citizenship. Then the contrast with the dual citizenship system in the United States, where the citizens hold both federal and state relationship. Okay, so this is the thing. Single citizenship single citizenship idea has been taken from United Kingdom. Then there is a Constitution of Ireland. The idea of directive principles of the state policy has been taken from Ireland. It is there in Part 4 of the Indian Constitution, which guides the state in promoting public welfare, draws the inspiration from the Constitution of Ireland in 1937. Okay, so other than this, the directive principles of state policy, the presidential election. This presidential election method, the method for conducting presidential election in India, was also adopted from the Irish Constitution. Okay, so as we talked about that, the presidential election method is quite complicated and it gets scary when we see to it in Lakshmikant. Okay, and this idea has been taken from Ireland. Well, we will just stop here. as I said that we are going to divide this whole thing into two different parts. One part we discussed about all the states, all the countries and all the features which have been borrowed from there, and then we also comprehensively discussed about what are those features which have been borrowed from United States of America, United Kingdom, and then Ireland, and why they have been taken. Okay, now there are 6-7 more countries, and these are the small countries. I mean the number of features which have been borrowed from these countries are quite small, quite less in number, so we can discuss it in next class in 15 to 20 minutes. We are going to stop here, and I want you to revise what you have learned here, what you have read here. We'll meet in the other class. Until then, take care. Bye bye. Like the video if you have liked it, share it with your friends, and subscribe to the channel. Thank you so much.